You don't come to this conference if you want people just sit there and, kumbaya with each other, because that's not the way it works. As I've mentioned before, one of the wonderful things, and one of the reasons that we have a conference where we still physically attend, is to see old friends, and to make new friends and to see old friends. And one of those is, poor woman doesn't even know what's going on behind her. Well, Erin worked for me when she was in the military. And one of those things about being in the military when you're responsible for other people, especially young people who get very excited about what they're doing, I got this picture from her. Now, what's wrong with that picture? Well, she was supposed to be in Kuwait. And she says, "Oh, General Dunlap, I'm in Afghanistan." Thanks for letting me know, Erin. I really appreciate it. And, of course, fast forward, she happens to be friends with Colonel Oler's spouse, who's on the left, who was my exec before Adam was. And I mention all this just to tell you that one of the great things about this area is the opportunity to get to know people. It's not a super large community, but it's a very interesting and a fun community. And Kate's now the chief prosecutor in the Air Force, and Erin is with the CIA and has been very much of a supporter of us down here. Thank you so much. Now, Dean Banks, and I say Dean Banks very specifically. He's the acting dean of the Syracuse Law School. He's been a great friend of the center here. In fact, I often say we don't have a conference if Bill Banks isn't here. And he's kindly agreed to come down again. And in fact, his textbook is the one that we use. His and the other author's textbook is the one that we use in our national security law course. I won't talk any more about his many accomplishments. They're right there in your program, except to say that Bill, I'm just so glad to have you down again. And remember this. Book signing, including his book signing, we'll hear a little bit more about that a little bit later on this afternoon, is from 12 to 3. Bill?
Thanks. Wardrobe adjustment?
Yeah,
I'm
we
good.
had a wardrobe malfunction there.
Afternoon, everyone. Thanks to Charlie and to Duke. I have done this conference many times, back to the days when Scott was running it, even back earlier when Robinson Everett was around, and this is really one of the preeminent national security law events in the United States year after year, and it looks like you may have hit an all-time high this year, Charlie. That talk, Craig, was a fabulous talk, and it's a perfect setup, I think, for the lawyers here to maybe take issue with a few things, but certainly get into some depth on some of the points that you raised. I couldn't be more excited to just moderate this distinguished group here, and I'm going to be very brief in my opening remarks. Every organized state in the history of the world has conducted surveillance. It's simply part of the instruments of governance in international relations. In the United States, of course, George Washington, as first president, hired spies. Think of that. That was before the internet. At the same time, not every state, but certainly the United States also has always highly valued individual liberties, including the right of privacy and rights of free expression that are protected in our Constitution. You all know at some level that there's a tension in the nation's need to gather intelligence through electronic surveillance and other means, and the individual's constitutional freedoms. We're here to talk about that. In contrast to this morning's discussion, which weaved together so many facets of international law, international criminal law, the laws of armed conflict, international human rights law, this afternoon we're going to be talking almost exclusively, although not exclusively, about United States law. But again, it's not one law or one set of laws. We're going to be talking about a range of authorities that our panelists will discuss with you here this afternoon, starting, of course, with our foundational document, the Constitution of the United States, but evolving over time through a series of statutory laws. Now everybody knows how to say FISA. That wasn't always the case. That's a prominent one, but several other laws, executive orders, perhaps even presidential decision directives, decisions of courts, agency regulations. It's another, I'm afraid, sir, it's a complicated mixture of laws that we need to unravel here, and we'll do that to some degree. The theme of the conference, hybrid threats, hybrid law, we concluded across the panel here, really doesn't apply to the subject that we're about to discuss, because whatever the environment, the tensions between surveillance and privacy exist. We simply have to deal with it, figure out how to manage it, and that's what we'll do. So we'll probably talk little about the distinctions between hybrid and conventional or any other environment, and just get squarely into the subject at hand. The group that we have here is, of course, well described in the program, and I'm not going to repeat the bios. I do want to say just a word, though, before we start a round of discussion here. Going down the panel, Charlie gave a very lovely introduction to Erin Wirtanen, but there's one claim to fame that Erin has that is not in the bio. She was my national security law student some years ago at Syracuse, and it's really nice to see you again, Erin. You didn't know that? Yeah. Next to Erin, Laura Donahue, who's the director of the National Security Law Program at Georgetown Law, by far and away the preeminent national security law program in the United States, principally, I think, because of her energies. As you look at her bio, you'll see that this is her strong suit. She is an expert in the subjects that we're about to discuss, and she writes prolifically about this. You'll see her book out on the table next to my book that you can look at after we're finished here this afternoon. I should also mention one other thing, because as we get into the discussion, this may be a factor. As a result of legislation that was enacted just last year, there have been reforms in the FISA court that caused the court to, for the first time, appoint amicus representative lawyers to sit inside the proceedings of the court in a classified environment. As many of you know, the FISA court has operated since 1978 in a wholly classified environment with only government lawyers present. Now there are amici that include Laura Donahue. She was a rare appointment and a special privilege, but it puts her in a somewhat different position than we academics, straight up. Next to Laura, Kate Martin, who, as I think her bio also reflects, is now fairly recently at the Center for American Progress running a program that looks at exactly the intersection of the issues that we're here to explore today. Kate is an institution in Washington and around the United States in the field of national security law. She's been a colleague and a friend for what, Kate, 25 years? I think so. And last but not least, Bob Litt is perhaps, no, not perhaps, he's the finest lawyer in the administration. He's the one who has...
You are causing me big trouble, Bill.
Yeah. He knows I'm trying to cause him trouble. Bob has been in the driver's seat as the general counsel at the ODNI since very early in the Obama administration, and as you now know, this is nearing the very end of the Obama administration. Bob was in the chair when the Snowden leaks occurred in 2013. Craig's story was very riveting. I remember hearing Bob tell about the vacation that he was about to begin on the night that the Snowden stuff started to hit the wire. And Bob has not only persevered, but he has led an incredible effort at transparency on the part of the administration in response to those leaks, but generally in getting the word out about what the government is doing in the area of intelligence and why it's doing it. And there's no better evidence of that than that he's here. Bob Litt is a very busy man who makes time routinely, in my experience, to do public events such as this one to talk about the issues before us. So, let's get started. We're going to just go around the panel one time to sort of lay the foundation for a discussion of contemporary issues. And there are many directions we could go. We could be here for the rest of the day on this topic, but we don't have quite that much time. Laura, let's start with you and get a bit of a history of the evolution of the interests that are at stake here and what's happened to American law.
Okay, thanks very much, Bill. And thank you, Charlie, for the invitation to be here today. Duke Law is really the preeminent institution, and this conference in particular, everybody knows about it in the country, so it's really a pleasure to be able to join you for the discussion. So as I look at the privacy and surveillance debate, certainly since the Snowden documents and certainly Craig and others' lives radically changed, that public debate, I'm reminded of Plato's allegory of the cave. We see these shadows on the wall in front of us while there's this conflagration that's just billowing behind us. What is that fire behind us? Well, Fourth Amendment doctrines, which were created in the 1970s and 1980s, no longer reflect how the world works. This has enormous implications, not just for foreign intelligence collection or criminal law, but for the future of privacy in the United States. Technology has basically propelled us into this new era. Rights are under siege not merely from government overreach, although they certainly are from that as well, but also from characteristics that are just unique to technology. So what are these characteristics? Well, digital information is non-terrestrial. It's borderless. Bits and bytes populate this alternative world. They may be held on a server, but data generation, transfer, availability, and analysis, that's not tied to territory, which undermines doctrines that rely on three-dimensional geography. Technology also embodies this efficiency drive. So innovation makes it possible for us to do more and to do it faster and cheaper than before. So if you have a doctrine that fails to recognize any privacy interest at the outset, the idea that suddenly a privacy interest would arise ex nihilo from nothing later on makes a very hard case to meet, despite the fact that you have much more serious inroads into individuals' private lives with the length of time the government places individuals under surveillance, the amount of information that is collected, the recording of that information, the combination of that information with other data, and further analysis of it. Digital interfaces, moreover, are rapidly proliferating. So these replace our traditional modes of interaction. What that means is there are enormous amounts of private information now available in the digital sphere, even as our ability to conduct our lives has become heavily dependent on technology. So it's a non-option to eschew the digital world if you want to live in today's world. As a result of these characteristics, particularly of digitization, the formal distinctions that have really protected the right to privacy are breaking down. They're really collapsing in many ways. I'd like to focus on three today during my remarks. First is the relationship or the distinction between private and public space. Second is the relationship between content and non-content, and relatedly personal information versus third-party data. And third is domestic versus international. Each one of these distinctions is just destroyed by digital technologies. All right, so let's start with public versus private. Fourth Amendment doctrine has long recognized the importance of protecting people within their homes from governmental intrusion. It was 1603 in Semane's case that Sir Edward Coke famously remarked, "The house of everyone is to him his castle and fortress, as well for his defense against injury and violence as for his repose." As Englishmen, colonists embraced this concept of the home. In his famous oration in Paxton's case, James Otis remarked, "One of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle." The Fourth Amendment took this understanding of the importance of the home as a protected sphere and cemented it into the Constitution in the Fourth Amendment. It eliminated general warrants, whereby the government could simply search around and look for potential evidence of wrongdoing and then use that to go after individuals. And it required instead a specific warrant supported by oath or affirmation, particularly describing the place to be searched or persons or things to be seized. Now, in contrast, the Fourth Amendment has no protection for what happens in public. The common law principle evolved into U.S. law. By 1924, in the case of Hester versus the United States, we then have the open fields distinction. Now, even in the post-Katz world in 1967, the court assumedly moved us away from a terrestrial understanding of the Fourth Amendment that relied on geography, on space. But actually, it just went on to retrench the public-private distinction. So in 1974, we have the case of Air Pollution Variance Board versus Western Alfalfa Company, where the court underscored that open fields distinction from Hester. A decade later, it reaffirmed its position in Oliver versus United States. This was when the Kentucky State Police searched a homeowner's field that had been surrounded by gates and was marked no trespassing. This approach continued in United States versus Dunn in 1987, when the court said that the space outside of a barn, even though it was located 1.5 miles from any road and surrounded by a number of fences, that was an open space and therefore open to surveillance. And that approach carried over to new technologies. So in the 1982 case of California versus Serralo, a plane flying 1,000 feet over a home in Santa Clara, California, my hometown, coincidentally, what anyone could see with their naked eye, so too could law enforcement collect. The same day that the court handed Serralo down, we have Dow Chemical, which established basically that the company has no privacy interest in what ordinary citizens could see. The same was true for a helicopter flying over the home in Florida versus Riley. And that approach continued to Knotts and Caro, the beeper cases with GPS chips in public space. So in each case, the argument that the court put forward was, well, when somebody's inside the curtilage of their home, they're as protected as a prince in their castle. But when you walk outside, then you're taking the risk that other people are going to see what you do, what you say, where you go. There's an assumption of risk that transfers. And what other citizens can see with the naked eye, then why shouldn't law enforcement be able to do that? In other words, why should we handicap law enforcement from what any citizen could otherwise see? And here's the rub. In the wake of new technologies, advanced technologies, and the amount and type of information available publicly, it's exponentially increased the privacy interest with very deep implications for our rights. So think about the just incredible explosion in the type of ways our location can be tracked. Wi-Fi and Bluetooth signals, global positioning system chips, vessel monitoring systems, radio frequency identification tags, automated license plate readers, international mobile subscriber identity catchers, IMSI catchers, network connection data like trunk identifier information, which will sound familiar to Verizon. The trunk identifier information is included, internet protocol databases, financial transactions, consumer purchases, closed-circuit television, remote biometric identification systems, unmanned aerial vehicles. The list goes on. These are just some examples. At the same time, mobile devices and watches and cars and credit cards and online activity constantly generates data that can be collected not just by the government, but by private companies. Yet the Fourth Amendment would have us believe that there is no privacy interest in where we go, what we do, and who we are with when we do so. The same is true of private conversations that take place in public, but social media has changed how we interact. Some interactions might be put online like Facebook, instant messaging, YouTube, Snapchat, or Vine, but they do not have the same protection that a conversation that you have with somebody sitting next to you on the couch would. They can be recorded, combined, and analyzed. Even when that data is entirely in the public sphere, the government's use of it may have a deep impact on free speech, the right to assemble, religious freedom, to say nothing of privacy. Okay, what about content versus non-content? That's another distinction, as well as this who holds the data question, which is the idea of personal information versus third-party data. Perhaps nowhere is the impact of this collapse more evident than in the Section 215 program. This was under Section 215 of the USA Patriot Act, the order that Craig mentioned during his address immediately prior to this panel, that under that clause, the government collected the telephony metadata of American citizens where there was, based on a clause in the Patriot Act that said you had to have reasonable grounds to believe that the information was relevant to an authorized investigation. The legal interpretation was all telephony metadata is potentially relevant, therefore we'll just collect everything. Okay, the idea here is that there's a distinction between content and non-content. And again, there are cases in Fourth Amendment law from the 1970s, Smith versus Maryland, and another case called Miller, where the court held you have no privacy interest in third-party data held by others, nor in metadata, in information that companies just collect in their course of business. And yet, none of us can go about our daily lives without entrusting very private, personal information to other companies. It is part of living in the modern world. It's an incredible stretch to think that we have no privacy information or privacy interests in this digital doppelganger that follows us around, that actually reflects what we do, what we think, and what we believe. It is an extension of ourself, and yet Fourth Amendment doctrine says, no, it's held by a third party. Or what about the metadata itself? Well, metadata, it turns out, gives incredible insight into individuals' lives. A recent study by computer scientists at Stanford University considered for a few months, 3 months, the phone records of 546 people. Looking at the numbers dialed, the patterns in the calls, they were able to ascertain highly sensitive and very private information. So one participant spoke at length with a cardiologist at a medical center, then talked to somebody in a medical laboratory, then received phone calls from a pharmacy and telephoned a home reporting hotline for a medical device that's used to monitor cardiac arrhythmia. Another participant called a firearms store that specialized in AR-15 semi-automatic rifles before calling a telephone service, customer service for a manufacturer that produces an AR-15 line. A third participant, you have to wonder if they knew they were in the study they volunteered for. They called a home improvement store, a locksmith, a hydroponics dealer, and a head shop. Kind of self-reinforcing. I'll take part. Anyway, a fourth person telephoned her sister and talked to her at some length. 2 days later, she called Planned Parenthood, and a fortnight later, she telephoned the clinic a few times. 1 month later, called it a final time. The telephone metadata provided insight into the participants' heart conditions, their gun purchases, their cannabis cultivation, and their decision to have an abortion. And it was 546 people over a 3-month period. Data is content, but metadata provides the context for everything we do. It can reveal the most intimate details of our lives, and it's far easier to sift through and to analyze than pure content. As NSA's former general counsel put it, Stu Baker put it, metadata tells you absolutely everything you have to know about somebody's life. He continued, if you have enough metadata, you don't really need content. It's sort of embarrassing how predictable we are as people. General Michael Hayden, the former NSA and CIA director, put the point even more succinctly. We kill people based on metadata. The content, non-content distinction breaks down in light of technology. Finally, on the domestic versus international, which also fails in the global communications context. Until the mid-20th century, the Fourth Amendment did not apply overseas. We had 0 Fourth Amendment rights outside the United States. There was a clear line drawn at the border of the United States. Following Katz, where the court adopted a new interpretation of the Fourth Amendment, basically that where there is a reasonable grounds to believe that somebody has a privacy interest that's supported both objectively and subjectively, that they would extend privacy protections. There was a moment of euphoria in academia, well, as euphoric as academics can be, much writing over how the Fourth Amendment was going to be extended overseas. But in 1990, there was a case called Verdugo-Urquidez, where Chief Justice Rehnquist came forward and said, well, actually, here's how it works. If you're a U.S. person overseas, you have some protections under the Fourth, but non-U.S. persons lacking a substantial connection to the United States have no Fourth Amendment interest overseas. A case shortly thereafter by the Ninth Circuit, Barona, verified this particular approach. So it turns out that we have a border. We have a border, and we draw a line as to what protections are inside or outside. So what happens when we have global communications? How does that work? Or how about foreign intelligence? So for foreign intelligence, the same border is drawn. In Katz, in footnote 23, for those of you who are into the case, so in Katz, in footnote 23, the court goes out of its way to say this doesn't apply to national security, right? We're not actually weighing in. But that, of course, doesn't stop Justice White and others from actually weighing in on the national security question. So Justice White, in his concurrence in Katz, actually says, well, look, when national security is on the line and we're collecting foreign intelligence, we should just let the president and the attorney general decide what information they're going to collect. This is not an issue for the courts. Of course, not everybody agreed in that case. Justice Douglas came back and said, since spies and saboteurs are as entitled to their Fourth Amendment protections as anybody, this must be a decision for the court. Now, Title III came out after 1967, after Katz. When Title III came out, there was an exception in the criminal law for national security purposes. And in 1972, the court confronted confronted a domestic security case, U.S. versus U.S. District Court. We refer to it as Keith, named after the first judge who ruled in that case. And in Keith, the court came out and said, well, look, if you're going to wiretap U.S. citizens on domestic soil, some sort of process is necessary for Fourth Amendment purposes. But they kicked the decision to the political branches. They said, we'll let Congress weigh in, and they invited Congress to legislate to address what would be the standard, the appropriate standard for wiretapping U.S. citizens. So in 1978, the Foreign Intelligence Surveillance Act, FISA, came into being, which drew a border at the edge of the United States and said, okay, everything inside the United States, that's electronic surveillance, and later physical search, pen register, trap and trace, and tangible goods, business records or tangible goods, everything inside the United States that's collected will have one set of rules. But outside the United States, there are no rules. Okay, so here's the problem. If I email one of my friends from my home in Bethesda, and she reads the email, let's say she's sitting out in Napa Valley, but it happens to go internationally, now it has weaker Fourth Amendment standards. It's not that my privacy interest in that communication is any different than if I emailed a fellow panelist and it just went straight between us. It is just by nature of the accident of how the internet works that it happened to go internationally, and my right to privacy has been constricted. Or how about cloud computing, or Dropbox, or Google Docs? Is all of this information fair game, so to speak, just because Google happens to hold the document in Singapore as opposed to San Francisco? So the problem, like the distinction between private and public space or content and non-content, has nothing to do with the privacy interests implicated and everything to do with new technologies in the digital age. So just to conclude, it's my concern, one of my biggest concerns, is that technology is playing a key role in collapsing these traditional Fourth Amendment doctrines, public versus private space, content versus non-content, personal information versus third-party data, and domestic versus international. And in the process, what's happening is we are losing the right to privacy, and this has enormous implications for us as we move forward. Thank you.
Are you ready now for a pop quiz? I don't think so. Bob, Laura sort of laid the table here.
Laid the table, set it with 12 pieces of
12
silverware in
pieces.
each setting.
Right. So can you clear it off, please?
I can yank on the tablecloth if that's what you're talking about.
We need to know, particularly since FISA, how the law has evolved, I think.
Well, I guess what I'd like to do is talk a little bit about some of the issues Laura talked about. Because I actually agree with a lot of her premises, although I think I end up taking them in a somewhat different direction at the end. I think Laura's absolutely right that the growth of technology has made the existing Fourth Amendment doctrines that we have, and I should emphasize that I'm speaking entirely for myself here, and in fact, if there's anybody here from the Department of Justice, don't shoot me. I think that a number of the doctrines that we have that have informed Fourth Amendment law for the last 50 years or so simply are not going to continue to work in the digital age for some of the reasons that Laura articulated. I think that the idea that there's sort of an on-off switch for privacy, depending upon whether you've given information to a third person or not, is not viable given the way the internet works these days. It's not to say that we shouldn't give different sorts of consideration to information depending upon who else has access to it. But the idea that if somebody else has seen the information, you have no expectation of privacy in it is not viable. But I think that we need to also take account of the realities of the situation from a national security perspective. I mean, the preamble of the Constitution starts out with the first duty of government is to provide for I forget the language. You can recite it, sure. Provide for the domestic security.
Provide for the common defense.
Yeah, and we need to be able to do that. And there's a whole lot of information out there that is remarkably useful and important for protecting national security. And I think that there are sort of two broad ways in which you could approach the kinds of problems that Laura has articulated. One is to say, we need to keep making the fences higher and higher and keeping more information from the government. And two is to say we need to find better ways of ensuring that what the government does, it does in an appropriate fashion. Let me talk a little bit about the 215 program, which I think is a good example of this. Because everybody knows that by now this was a program that collected metadata in bulk. And everybody knows, as Laura said, that there are a lot of things you can do with metadata, metadata individually or metadata in bulk. What's missing here is the fact that the government did not do any of those things with that data. What happened here was a whole bunch of metadata that sat on servers at Verizon and other companies was transferred to servers at the National Security Agency. And the only time anybody knew what was in there was under circumstances that Congress has actually approved since then, because, as you may know, last summer it passed something called the USA Freedom Act that says the government can't hold this metadata in bulk anymore. You have to go and get the data from the telephone companies on a one-off basis. But you can get it under the exact same circumstances that you could have gotten it before under the 215 bulk metadata program.
Brief point of clarification. Yep. Explain what metadata is.
So metadata, there are some people in this room other than me who are old enough to remember telephone bills that itemized your long-distance phone calls. And metadata is basically that line you used to get for each phone call. It's the number making the call. It's the number you're calling. It's the date, time, and duration of the call. It's not the identity of the person. It's not the content. It's not in this particular program, although there's some question about the legal status. It was not cell tower location data. It was just essentially information about the call itself. It was not the call. And the way the program worked was if the government got a telephone number that it had reason to believe was associated with terrorism in some sense. Let's say there's a terrorism camp in Yemen that's raided and they discover somebody's phone book with some phone numbers in it. They could take those phone numbers and they could go into the database and they could say, has this phone number been in touch with people in the United States? Because if so, maybe we want to do a little more inquiry into those phone numbers. Any additional inquiry had to be passed to the FBI for the FBI to use traditional subpoena, warrant, investigative powers that it had. But the point that I was making was that was the only time that anybody looked at that bulk metadata. And Congress has agreed that that's a reasonable use to make of the metadata. So really the only thing that happened in this program was that ones and zeros that previously sat on one computer now sat on two computers. They sat on a computer at Verizon and other unnamed companies, and they sat on a computer at the NSA. The point that I have been trying to make on this is that we need to find ways to enable the government to do the things and collect the information that's necessary for national security, while giving us some sufficient assurances that that information is not being misused. The 215 program did that by locking down the databases. It's interesting that Snowden has never claimed that he had access to that database because he didn't have access to that database. Very few people had access to it. They made a record of all the times the database was queried, and those queries were all monitored and audited to ensure that they were all appropriate. And so there are ways that we need to be thinking about where we can impose appropriate restrictions with appropriate controls on the use the government makes of information it gets to provide the guarantees that we need to ensure that the information that we need to protect people is not being misused. One other point I want to make about the issue of the territoriality of the Fourth Amendment, and that is that we can't simply go away from territorial limitations. We had 100,000 troops on the ground in the Middle East. Those troops needed to be able to collect information for force protection purposes. It is simply not going to be viable to make that subject to the requirements of the Fourth Amendment. We need to be, there are all sorts of other kinds of activities. It's inconceivable to me that we would say that we need to go to a court to get a warrant to collect the communications of Vladimir Putin. And so I think that we need to think about that. I agree that there are some issues about territoriality that are going to be complicated to work through, but it's another support for my overall principle that we need to be looking not only at the act of collection, but at the use that the information, that is made of the information and how we can regulate that. One last point I want to make on this regard, and that is as an example of where I think the Fourth Amendment, the existing Fourth Amendment doctrine is unrealistic, but not necessarily an example that Laura would agree with. And that is that there's litigation out there challenging another one of the collection programs, something called upstream collection, which is basically collection pursuant to Section 702 of FISA of communications from the internet backbone. I don't want to talk to that in great detail, except to understand that they were looking, this was not a bulk collection program. This was a program where they had specific, what they call selectors, email addresses that they were looking for. And they were collecting only communications that were either to that email address, from that email address, or where the email address was mentioned in the communication. Now, in order to, the way the internet works, I'm not a technologist, but I'm pretty sure that the way the internet works, you can't find those communications unless you look at everything that's crossing the stream. You have to be able to look at that and pull out the communications that are to, from, or about that selector. But there is litigation in which people are claiming that that is an unreasonable warrantless search because there are Americans' communications flowing across the same backbone. That's simply not tenable. And to the extent that existing Fourth Amendment doctrine compels that result, I think that's another way in which the modern technology compels us to relook at Fourth Amendment doctrine.
Thank you. So, Erin, we all watch Homeland. And the CIA often is taken...
Totally realistic, right?
What's that?
Totally realistic, right?
Totally realistic. The agency has taken some lumps in its activities with regard to surveillance over the years, and it operates within the system that both Laura and Bob have begun to describe. How does it look from your perspective inside the agency?
So first, one of the biggest questions I get since Homeland became so popular is, does the agency hire people who are bipolar? The answer is yes, we do, actually. So not a limiting factor. I just want to thank, of course, General Dunlap for having me here again. And law students out there, be nice to your first-year con law professor because he could be grilling you as a panelist 20 years down the line. So no, I think there's a lot of good things about what Bob said, of course. I agree with Bob completely. But I do, I'm worried about my career. No, just kidding. So
I have no authority over her.
So I do want to address some of these things that we've talked about. We've addressed some sort of criticisms of the intelligence community and the CIA, and I'd like to kind of go through those, get them out of the way up front, as well as some of the points that Laura's already made. I'll call it my top 5 list. So top 5 sort of criticisms of the CIA and intelligence community, and then I'll address each one briefly. The first, the CIA operates without any or enough oversight from Congress or the public. 2, the CIA conducts domestic spying. 3, the FISA process is a rubber stamp for the intelligence community and not a meaningful check and balance. 4, the intelligence community cannot point to a single terrorist event that was prevented as a result of the collection of bulk data. And 5, the government must be controlled because they have so much information on me. So let's go through those one by one, and let's take the first one first. The CIA operates without any or enough oversight from Congress or from the public. And I want to assure you that I don't think that's true at all. There is congressional oversight. Congressional oversight is justified by 2 main things. First is the necessary and proper clause of the Constitution, since courts found that that clause includes the power to require reports from the executive on anything that can be legislated. And second, the Congress has the power of the purse, which, believe me, has a lot of power associated with it.
You did have a good con law teacher, didn't you?
Yes, I did. The best. So those are very important points. And there are 2 major committees, of course. There's the HPSI and SISI. HPSI is the House Permanent Select Committee on Intelligence, and the SISI is the Senate Select Committee on Intelligence. The HPSI is about 22 members, and the SISI has 15. 8 are from the majority party, regardless of the ratio of majority members in the Senate. Now, 4 members of the SISI have, after 9/11, are dual-hatted, which means they're all associated with another committee. Each one has a different committee that they are part of. Those 4 committees are the Appropriations, the Armed Services, Foreign Relations, and the Judiciary Committees. So the HPSI and SISI do have the authority to perform oversight functions for the CIA and the intelligence community at large. There are other oversight mechanisms that exist. The Office of the Director of National Intelligence also has an oversight function. Department of Justice. The FISA Court, I would say, has a oversight function. The President's Intelligence Advisory Board, which is used to carry out investigations and initiate analysis activities for the President. The Office of Inspector General, which carries out a lot of investigations to agencies, including whistleblowing, fraud, audits, special reviews, to detect and deter all sorts of fraud, waste, abuse, and misconduct, and to promote effectiveness and efficiency. And then, of course, the National Security Council has an oversight function. So let me take the second criticism next. The CIA conducts domestic spying. So unlike the Federal Bureau of Investigation, the FBI, which is a domestic security service, CIA has no law enforcement function in the U.S. or period, and is mainly focused on overseas foreign intelligence gathering, with only a limited foreign intelligence collection inside the United States. As you may recall, back in the 70s, there was the Church and Pike Commissions, which found the CIA was acting as a rogue elephant for some domestic spying charges, such as domestic spying on the Black Panthers and anti-war movements. And post the 70s, when those commissions came out with their reports, Executive Order 12333, or 12333 as we call it, came out. And that did constrain the CIA from engaging in domestic spying activities. Section 2.4 of EO 12333 specifically says the CIA cannot conduct unconsented physical searches in the United States. Third criticism was the FISA is a rubber stamp process, and it's not a meaningful check and balance. People who give this criticism, they like to quote the statistics, and so I'm going to give you the statistics up front. The FISA court's been in existence since 1979, and for the first 33 years, they oversaw, 33,900 ex parte requests to the court. And the judges, out of 33,000 plus, the judges denied 11. And they granted the rest. That's a 99.97 approval rating. In 2013, the government made over 1,500 requests, and none were denied. But the court did modify 34. And in 2014, the U.S. government made 1,300 requests, and none were denied there either, but 19 were modified. Now, critics will say that's a sign, it's a rubber stamp, that the FISC will give the U.S. government whatever they ask for. But I think the fact that there's a high approval rating actually proves the opposite. It proves that the executive function, the U.S. government who is presenting applications to the FISA court, is vetting them, is making sure they have legitimate targets of interest, is making sure that they've properly supported that in their documentation, and they're giving a fully vetted, proper package to the court, which is why they're not being denied. The alternative, if you agree with the critics, would be that the U.S. government provides lots of applications on unvetted, unsupported targets, and then we'll see a much higher denial rate. But I don't think that that's the best way to go for our government as a whole, or for national security. So fourth, The IC cannot point to a single terrorist event that was prevented as a result of the collection of bulk data. And I do want to actually approach some points. Bob gave a great discussion of Section 215, and I think that's very educational because sometimes the enthusiastic press reporting makes it sound like something it's not. And I think what Bob said is completely accurate to give us a good view of what it is. Yes, metadata does disclose a lot of personal information about us. There's no question about that. But Bob's counterpoint to Laura's was a great one. Who's looking at it? Let me tell you, the U.S. government is probably not looking at it. You know who's looking at it? And I'm not talking about necessarily call detail records, but who's looking at it? Data aggregators, data brokers are looking at that data. And yes, ma'am, I loved your question earlier. Not my plant either. But yes, those are the folks who are looking at your information. And let me get back to the question here. The IC cannot point to a single terrorist event that was prevented as a result of bulk data collection. I'll tell you why. I can give you a really good answer to that. Because it's one little piece of a picture, of a big picture. And it's impossible to say which piece was that one piece that led us to the full picture to know what was happening. You take a picture, a puzzle of the face of a dog, and a 500-piece puzzle, if you're missing 10 pieces, do you know it's a dog and not a cat? It depends on where those pieces are. It depends on what they show us to tell us that information. So that's why it's hard to point to a single evidence of one bulk data collection that resulted in a terrorist plot thwarted. And that also kind of bleeds into my next point, which is the government must be controlled because they have so much information on me. Bulk data aggregators, do you know what they collect? Your age, name, gender, address, previous addresses, economics, your income level, your profession, your religion, your weight, your dress size. They also collect your medical information. Do you have diabetes, cancer? Do your children have ADHD or autism? This is the information that they collect. And I have to assert to you that there's no regulation that regulates the flow of this data specifically. There are some laws that protect certain pieces of that data. But what we're relying on right now, from a legal perspective, in my view, is the data aggregators' moral compass in who they sell this data to. Now, I'm going to contrast that, and for those of you who heard me speak last year, I talked about this quite more in depth, but I just want to contrast that for 1 second, and I'll move this along, with what the U.S. government does. There are protections on your data. First, there's law, constitution, federal law, as well as regulation, presidential directive, executive orders that protect how your data is seen, used, disseminated, and retained. So as a whole, there is a lot of protection in place, in my view, in the government's use of data.
Thanks, Erin. Kate, we've been talking about privacy, but we've sort of been beating around the bush. Tell us more about the interests that are at stake in these various controversies that arise. What is privacy? What dimensions matter when we talk about surveillance?
Yes. Well, first of all, I want to thank you, Bill, and General Dunlap for inviting me to come here. I would say that in my kind of career as a civil liberties and human rights advocate in this field, the little that I learn, the little that I know, I've learned in large part from the kind of openness and willingness of people on the inside, either in the military or in the government or sometimes in academia, to talk about how things work and to engage in discussion about the hard problems. And so for all of you students out there who are interested in either going into the government or into doing human rights, I urge you to make a study of the other side's viewpoints. So what I thought I would do was just remind us of the specific rights that we're talking about when we talk about these issues and the specific harms that we want to be concerned about when we think about relooking at Fourth Amendment doctrine, something that both Bob and Laura think is necessary. First, make a couple of points about what I don't think matters in this discussion. And that's two kinds of harms. One is that there is the possibility that rogue government employees who have access to Americans' individual information will do something wrong with that. They'll either steal it or they'll use it to blackmail somebody or something. That occasionally happens. I believe it is illegal whenever it happens, and I suspect that in most instances, which aren't very many, that when it happens, that employee is sooner or later found out and punished for it. I don't think that's the risk when we talk about government having access to our personal information, nor do I think that the fundamental risk is that the government is going to lose or make vulnerable its databases to bad actors, notwithstanding the fact that the Office of Personnel Management did not manage to protect the personal information of millions of us who had applied for various positions in the government. That was a mistake that they're working very hard, and I won't even mention Mr. Snowden's access. Those were mistakes that they're working very hard on preventing happening again. And I don't think that they're the chief evils that the Fourth Amendment is designed to prevent. So I want to talk about what I think matters when we talk about when Bob says we want to prevent the misuse of information that the government has. And I want to first say that I'm only going to talk about information that the government has on Americans, not because I believe that foreigners overseas have no human rights interest in how the U.S. government deals with that information, but because the legal regime that protects them, which has recently been acknowledged by the president himself in an order in which he said the U.S. government needs to respect the human rights of foreigners overseas, is quite different from the Fourth Amendment legal regime, which Laura laid out. And because Verizon is going to look out for the interests of those customers. And I think that the harms that people risk when the government has their information are different if you're talking about your own government having information than if you're talking about a foreign government having information on you. And your expectations are different, et cetera. So I think that the first interest that's fundamental is the right against unreasonable searches and seizures, which is codified, is set forth in the Fourth Amendment. And just for the sake of kind of completeness, Laura already outlined this, but to remind us that what the Fourth Amendment talks about is unreasonable searches and seizures, and then it says that searches shall be conducted with a warrant issued by an independent magistrate.
Not exactly what it says.
That's not exactly what it says.
It says no warrant shall issue but upon probable cause.
Okay, no warrant shall.
Which meant.
I understand.
Okay, so now we're going to.
As an historical matter, that's exactly what it
whether or not a warrant is required. That's what they are talking about. Whether or not a warrant is required.
A warrant is required. That's
yes.
The history on this point is incontrovertible.
Okay, history.
Except that it is in fact controverted.
No. It's not.
We haven't even
Now,
gotten
now.
to the elements of
I
the
do not think that
warrant.
word means what you think it means, Laura.
Okay. First, we're going to start with the elements of the warrant, and then we're going to get to when there's no warrant required, and it only needs to be reasonable, okay? So the elements of a warrant are an independent magistrate issues the warrant upon probable cause. The warrant has to specify with particularity the places and the things that need to be seized. And finally, the Supreme Court held in a law enforcement context, not a national security foreign intelligence context, that the Fourth Amendment included the requirement that the government give notice to the person whose things were being seized, that the government had done that. So that goes to the question of whether or not secret wiretaps and secret searches where the American whose conversations or things have been seized is never informed of the fact that the government has in fact gotten them. So that, now of course there are, the courts have recognized that there are lots of exceptions to the Fourth Amendment, that the reasonable expectation of privacy may be a adequate substitute for an actual warrant when the Fourth Amendment applies. They've also come up with a list of situations that Laura went through in which the Fourth Amendment is deemed not to apply at all, so you don't need to meet either warrant requirements or reasonable expectation of privacy requirements. That includes third-party doctrine, open fields, et cetera. But I want to go back for a second to a case that Laura mentioned and just look at it a little bit more because it's one of the last times that in this field, my side won a case in the Supreme Court on surveillance. No, that's not precisely true, but which is the 1972 case in the Supreme Court called the Keith case. And in that case, up to that time, every president, I think beginning with FDR, had authorized the Attorney General and the FBI to conduct warrantless wiretaps on Americans for national security purposes. And that had been done in secret. That power had not been claimed publicly. And in the Keith case, a criminal defendant who had been wiretapped under that authority challenged that wiretap as a violation of the Fourth Amendment. The Supreme Court held that that warrantless wiretap undertaken for, quote, domestic security purposes was in fact a violation of the Fourth Amendment. And in that case, you'll have to correct me if I'm wrong, but I'm pretty sure that that case grew out of the investigation of a real crime, which was that some anti-war protesters had set off a bomb in the University of Wisconsin, Michigan math department. And while they'd done it in the middle of the night, in the hopes that no one would be there, in fact, a graduate student was studying and was killed. So it wasn't a theoretical, it was a real criminal case. And Justice Powell wrote the opinion in the case, and he made a couple of points which I think are still at the heart of what we're talking about. The first one is he said, and he talked about what we're looking at is the way in which the reasonableness requirement of the Fourth Amendment, quote, derives content and meaning through reference to the warrant clause. So that concept, I think, has been eroded over time. But he then went on to talk about national security cases reflect a convergence of First and Fourth Amendment values not present in cases of ordinary crime. Though the investigative duty of the executive may be stronger in such cases, so also is there greater jeopardy to constitutionally protected speech. And then he explained the connection between the First Amendment, protection of First Amendment rights, which would include not just free speech, of course, but religious liberty and the protection against unreasonable searches, and said, history abundantly documents the tendency of government, however benevolent and benign its motive, to view with suspicion those who most fervently dispute its policies. Fourth Amendment protections become the more necessary when the targets of official surveillance may be those suspected of unorthodoxy in their political beliefs. So I would assert that the first issue and the first harm that we're looking at is, are our Fourth Amendment rights being respected? And then I think we have to look at, as Laura laid out, technology and the law have changed in really fundamental ways, basically adding up to the amount of digital information available about individuals has vastly increased. The government's ability to collect that information, to store that information, and then to meaningfully analyze that information has vastly increased, in part because the costs of doing so have vastly decreased. So while it's true that I think data aggregators may have as much or more information as the government does, as Erin pointed out, I think the question in terms of the Fourth Amendment and individual liberties vis-a-vis the government is, what are the particular risks and harms that come from the government having these kinds of capabilities that may not come from data aggregators who want to sell you products having these capabilities. And just to run through two of them really quickly. So the first one, to be provocative, is that in the words of Richard Clarke, who was President Bush's counterterrorism advisor, and who then looked at this as part of a panel for President Obama, the NSA has created the potential for a police state. Now, before Bob says anything, Mr. Clarke was quite clear, and I agree with him, that we don't have a police state at the moment. And there isn't any evidence that there's nothing in the Snowden disclosures that establishes political spying by the United States government of people in the United States. And so, but what Clarke talked about was the potential, not that it had happened. And so I think one of the questions that we have to ask when we talk about changes that we need to the Fourth Amendment is, are the rules that Bob's talking about that would protect against abuses going to be sufficient to protect against the creation of a police state, should there be people in government who were interested in creating such? And I have to say that the statements by some of the current leading political candidates, would make one worry about using government resources to target people on the basis of their religion, which is one of the aspects that's a characteristic of the police state. But I think there are two other aspects of the rules that make writing those rules difficult. One is they're enormously complex. They're hard to understand, they're hard to write, et cetera. And secondly, they're at least they deal with what happens in secret. Sometimes they're written in secret, sometimes they exist in secret. And that makes it much more difficult to know how they're actually working, whether or not they're actually preventing the kinds of abuses that they're meant to prevent. So the last risk that I want to mention, in addition to the kind of government spying on dissenters problem is the risk that those in charge will use these capabilities, these surveillance capabilities, to violate the law. And that in itself, whether or not it's done for a good purpose or a bad purpose, has a fundamentally corrosive effect on our democracy. And it's not a far-fetched possibility. In the last 15 years, it's happened twice, in my judgment. The first time was during the Bush administration, when the Justice Department and the White House claimed in secret that the protections and authorities written into the Foreign Intelligence Surveillance Act did not apply to the situation. It could be overridden and ignored if the president determined that doing so was in the national security interest. And just to be clear, what those protections and authorities were that were violated by the Bush administration in their warrantless wiretapping program were rules on listening to the contents of Americans' telephone conversations with individuals overseas. And just to put it in a larger context, they did this at a time when they made no public claim that there was some commander-in-chief authority to ignore this law. So no one could object to it because no one knew about it. Nor did they even make the claim that this was the only way to acquire the contents of communications between terrorists and Americans. And they didn't make that claim because that just would not have been true, because they could have gotten a secret FISA warrant for those communications in 2 seconds, or they could have gotten a change to the law. But the other example, which actually saddens me to say, is that I think is the 215 program. So the 215 program, I agree with Bob's description that it was locked down in the sense that people inside the government did not and could not get access to the metadata that was collected under the 215 program. But here's the thing about the 215 program. This is what it was. It was a program that said, we're going to use 215 of FISA to order the telephone companies to give us the metadata on all domestic phone calls inside the United States, all telephone calls between and among Americans. So last summer, the Congress looked at that program and said, yes, we approve that kind of collection under the following rules. And they changed the rules, but they approved the collection. But what happened before that is that interpretation of the law, that the U.S. government should have and did have the authority to collect that kind of metadata on Americans, was a secret interpretation of the law. And so in my judgment, it was not democratically decided. People disagree because Congress knew about it, but the public didn't know about it. There was no public debate about it. And that it is a perennial temptation in this field to say, we cannot talk about this, and therefore we have to do it, and so we'll go ahead and do it. And when it turns out, I don't know, but I would say that it's not that there's never any national security harm from classified information being made public, and there clearly is, and there clearly has been with Snowden. But on the other hand, when you're talking about information that goes directly to decisions that are going to be made by the Congress about Americans' individual rights, that in the long run, keeping that information secret not only undermines the democratic process, but it turns out to be bad for the national security and foreign intelligence enterprise.
Thanks, Kate. Two quick things before we get to your questions. Laura, you drew a line properly between authorities that apply inside the United States and those that apply outside. Today's New York Times ran a front page story about some developments concerning that law.
Wasn't front page.
It was inside page. Mr. Litt is quoted amply in the story, and we won't insist that he'd speak about it. But Laura, what's at issue with the authorities for the United States to conduct surveillance outside the United States, particularly as pertaining to U.S. persons?
Yeah, I'd like to respond to that and also to some of the comments that have come up during the panel. And this relates to, in terms of the warrant requirement in the Fourth Amendment, I know Bob is not an historian, so he can't be faulted for not knowing the origins of the Fourth Amendment in this sense.
I would say only, Laura, that if there's a matter on which you and Akhil Amar disagree, I would not consider it to be incontrovertible one way or the other.
So what Bob is referring to is I have an article about 100 pages coming out in the University of Chicago Law Review looking at the origins of the Fourth Amendment. It's something I've looked at for the last 3 years. Very carefully, Akhil Amar had an article in the 90s in which he asserted, with no support for his assertion historically, that the warrant requirement is not part of the Fourth Amendment. But if you read the text, and if you hew just to the text, it says that when a warrant shall issue, it shall be accompanied by probable cause. Every historian, legal historian as well as historian in American law, the history of America, has looked at that and said that he's just dead wrong. And the reason why, and I'm a historian as well, the reason why is because at the time of the founding, you could not enter into somebody's home without a warrant, which is why there was so much pressure, even in the common law, on general warrants. Because the only exception to this, and they're English common law. And if you go back to Lord Cook's writings and his institute, you go back to Hale and his history of the pleas of the crown, you go back to Hawkins, the only time the government could enter was when it actually had a warrant to do so, which is why the English government started increasingly trying to use general warrants to gain access to more homes. The only exception was the fleeing felon or the hue and cry, when people would go after the fleeing felon, and then they would have permission to enter a home to capture somebody who had just committed a felony. So at the time of the founding, when Paxton, in Paxton's case, James Otis took on the concept of a general warrant. He said, "I will to my dying day oppose this instrument of tyranny on one hand and villainy on the other," because with it, the government could become a despotic ruler. And John Adams, he was president at the time, second president of the United States, later said, "Then and there the child liberty was born. It was the first shot of the revolution," and it was decrying general warrants. So all of our state constitutions at the founding went on to prohibit general warrants and to require that if the government went into a home, they had to have a warrant to do so. So unreasonable at the time of the founding meant against the reason of the common law. It was a very common trope in the legal writing of the time, unreasonable against reason, against the reason of the common law. It went against the common law to allow entry into your home absent a warrant. So that's the historical point. On this broader point, I do want to raise as well, which is the who is looking point. I've always been kind of confused by this argument. You know, if the government were to go into your house and say, "We're going to put a camera in your bedroom, and we're just going to collect everything you do, but we promise we won't look at it unless we have a really good reason to do so," I don't think we would feel very comfortable with that. And there's two reasons why, right? First of all, privacy is determined from the object being put under surveillance, not by the government, right? It's my privacy that's at stake. And second, we don't trust the government. And there are good reasons that the founding generation understood. And there were three in particular, which is why we didn't allow general warrants at the founding. The first reason was it was too much power. It made the government despotic. It gave them all of this information that could be used to silence political opposition, people who disagreed with them. So I write about this in some detail in the book. Going back to history, we have good examples of where this has actually happened. But the second was institutional. We have a separation of power system. This is a deep constitutional question here. Do we want the executive branch being able to collect information about the judiciary and about Congress, and about members of our judiciary and members of Congress? It can override structural protections built into the system and federalism. It can also override federalism distinctions. And at the time of the founding, you see writings about this, about why the government should not be given broad access to search anybody it wishes without particularized suspicion of a crime, naming that crime under oath, and getting a judge, a third party to issue an order allowing it. And the third and final reason has to do with private lives and social values and humanist values, our need for intimacy and to be able to regulate our intimate.
Put cameras in everybody's bedroom and say we'll only look at it under appropriate circumstances. I do think that most reasonable people would accept that there's a difference between a camera in your bedroom and telephone metadata. And that's why I say I think the nature of the data as well as the use the government is going to make of it are factors that need to be considered in determining what's appropriate activity for the government to be doing, and that it needs to focus both, as I said, on the collection side and on the use side.
Maybe to say,
as Jim Comey said the other day, this is a really hard issue because there are important equities on both sides of the equation. I think it's interesting. I think Craig's comments suggest that perhaps telephone companies may have a slightly different view of the equities here than some of the Silicon Valley companies do. I have always felt that this is an issue that needs to be resolved through the political process. The problem is our political process is not very capable of dealing with big, complicated issues right now, and let alone small, trivial issues. And we need, and yet the problem is out there. You know, a judge, either the FBI can unlock the phone, or the FBI can't unlock the phone. One way or another, there's a decision that's going to be made. And in the absence of Congress acting, the question is, what's the appropriate decision here? I am not going to talk about the case in particular, but for people who suggest that the loss of ability to access the plain text of encrypted communications or data, for people who suggest that that is not a real problem, that's just wrong. It is a real problem. It may be a problem that is not soluble and the government may have to tolerate that. But it will mean, and has already meant, a loss of capability to understand what people who are trying to do us harm, what they're doing, what they're planning, and how they're planning it.
quick two-finger, and then we'll go to questions.
Yeah, so this is a little bit, again, confusing to me. When Congress doesn't do what the administration wants it to, suddenly it's being intransigent and not working, and we have to go around it by using the All Writs Act.
No,
Let me
Laura,
finish,
that's
Bob,
totally unfair.
let me finish my statement. So when the Congress doesn't act and they're not able to, that is part of the constitutional design. If Congress has not passed a law under an enumerated government where the executive branch may only do what Congress tells it may do, then it has chosen not to do so. And this has always confused me when people say, oh, well, Congress just refuses to play the game with us. Well, because their answer was no on that. You know, the Apple case is not just about unencrypting a phone. It's not just about incinerating what's inside of a safe. It is about if you have any privacy interest in digital data. If this is done, you have no privacy, there is nothing that you can withhold from the eyes of the government and potentially from hackers and others. I mean, that is in many ways, and that's why I think Apple is actually pushing this so hard. This case is about whether there is any sort of digital data that you can keep so private that nobody can see it, so that it's akin to what you say to your spouse inside your bedroom. Is there any way that digital information can be protected? And in many ways, I think this case is about that question.
So if I could just respond briefly, Laura, the problem is you assumed the conclusion in your initial comment. You assumed that Congress, by virtue of Congress not acting today, the government has no authority to do this. The government's position is, by virtue of Congress not acting today, it does have authority to do this under the All Writs Act. And that's my point, that until Congress confronts this problem directly, the courts are going to have to make a decision, one way or another. I didn't mean Congress acting in the way the intelligence community wants. Congress has not addressed this issue at all, and it needs to.
I believe there are some questions. Let's take. Ma'am, are there microphones? Yes. In uniform here. Please keep your question brief. We only have about 10 minutes.
To the Constitution have always come responsibilities, and to the President is given great responsibilities, who gives us the majority of our authority in uniform to act. You know, that's the branch that we're falling under. So when you're talking about responsibilities, historically, when you didn't even have the right to vote unless with it came the responsibility to serve on a jury. We're forgetting that the president has a responsibility, the Congress has a responsibility, and each of us in uniform who are doing these jobs have responsibilities. So I think we're really begging the real question that I have is privacy truly a right? This is something we've seen created by the courts in the last 40 years, not in our homes, like in a Fourth Amendment concept, but is it really a right? And then the real question is should it be? And we've got people on opposite sides of the fence, and so I think it's a great point of discussion is should it even truly be a right?
Erin, you want to start this one?
Yeah, so I think that's an excellent question. Is privacy a right? And I think the way I look at this is as a balance, right? We've got privacy on one end, which is important. And by the way, I love Laura's passion because I'm also passionate, even though I may disagree with her. I think passion is important in this topic. But we've got privacy on one side, and the other side we have the title of this panel, surveillance, but I'll say national security on the other side of this weighted scale. And the question is, what do we, and I ask you to ask yourselves this question, what do we value more? Because if you think our adversaries aren't collecting data on us, if you think our adversaries aren't plotting against us, and that they don't pose a risk to national security, you are kidding yourself. But privacy is also important. And I understand our need to not have the government have a camera in our bedrooms, even whether or not they're going to look at the data. So that's what we need to, as a society, determine what are we most comfortable with? How much privacy are we willing to give away in order to secure more of our national security interests? And I suggest it lies somewhere in the middle.
Let's hear for Kate briefly, and then a next question. Kate?
So I would just say that that's an oversimplification of the choice. That if you just start from the simplest example, the government has a right to actually have a camera in your bedroom if it has a warrant, and the warrant meets Fourth Amendment requirements. So what we're talking about here is, are there situations in which the government can get private information when it doesn't meet standard Fourth Amendment warrant requirements? And we've already answered that question to some degree in the law in the United States by setting up the FISA, which is an alternative kind of warrant requirement, which allows the government to get private information, including wiretapping the phone conversations of Americans for national security purposes and never telling them that they've been wiretapped. So that's in the law. And we're looking at much harder questions now. And I don't think it's answered. I don't think that the president's Article 2 power says anything about this, really, because the Fourth Amendment isn't overridden by the president's Article 2 power, which is about what he can do overseas. So what I was trying to say is that I don't know that talking about privacy versus surveillance gets us very far either. That the question is, what are going to be the rules to access what kinds of information under what circumstances, and what are the interests at stake in writing those rules?
That's a helpful clarification.
You
Craig,
agree?
I totally agree.
down front. Craig, I think this is the last question. Charlie's looming on my shoulder here.
Laura, you mentioned Smith v. Maryland that says third-party doctrine, no right to privacy, and in metadata you hand to a third party, and Bob, you mentioned that may not be tenable. If you're sitting here 5 years from now, is Smith v. Maryland still the law of the land, or does the Supreme Court overturn it?
So I'd say they're going to overturn it. And I would look to Jones, the shadow majority in Jones. So in the Jones case, there was a suspected drug dealer in Washington, D.C. They got a warrant to put a GPS device on his wife's car. 11 days, so outside the warrant period, they attached the device to the car and followed it for 28 days. And in that case, Justice Scalia authored the opinion based on trespass. The court went along with him, said it was a trespass. It's almost quaint, right? Like in 20 years, we're going to look back and think, oh my gosh, trespass. But 5 of the justices justices in that case, in opinions authored by Justice Alito and Justice Sotomayor, and particularly Justice Sotomayor, said she would actually jettison third-party doctrine altogether. So I think the court, in many ways, is moving in that direction, but of course now, with an open spot on the court, I think a lot hinges on the next appointment to that court, certainly for the future of third-party information.
Bob, you have the last word.
Yeah, well, I want to say first, I actually don't think the court is going to overrule Smith v. Maryland, but I think if you look at what happened with the other case Laura mentioned, which is Miller, which had to do with bank records, what happened was Congress stepped in, passed the Right to Financial Privacy Act that imposed legislative regulations. I think that's a more likely outcome, that there will be restrictions that will allow the one-off pen register that it was at stake in Smith and have greater controls on bulk. I actually want to also address the question that was asked, Craig, at the end about advice for law students, which is something that I do a lot in this kind of environment, because I really encourage people to go into government service. I've been fortunate in my career. I've spent about half my time in government service and half in private practice. And I can say pretty wholeheartedly that except for twice a month, the worst days in government are better than the best days in private practice. Twice a month, private practice is unquestionably better. But the rewards and the satisfaction that you get from working for the public are immense. And I just have 2 words of advice for people who, from my perspective. One is, there are a lot of people who are coming out of programs like this one who have taken courses in national security law. In fact, we're flooded with applications right now. But I run a general counsel shop for an agency, and I need to have people who not only know the law of armed conflict and surveillance law, but people who know budget law and procurement law, human relations law. And if you want to get your application, your resume looked at when you apply for a job, take some of those courses as well, because that'll get you to the head of the line. The second bit of advice I have for people is a lot of people go into private practice for a while, pay off student loans or whatever, and then look to go to government. And that's a highly commendable path, but watch out for the golden handcuffs. When Bill Clinton was elected president, I was a partner at a law firm in Washington, and several of my partners were desperate to get a job in the government, and they looked at the 3 kids in private school and the house with a large mortgage, and they said, I can't afford to do that. So if you think you want to go into private service, public service at some point, when you're in private practice, live like you're on a government salary, because
Well, as I've said a number of times, if you wanted a consensus panel, this is probably not the conference to come to. And Bob, I want to particularly thank you for those last words, because that's the kind of guidance that law students are really thirsting to hear. And I really appreciate it, and appreciate everybody on the panel taking the time out, because we have a number of students from a number of schools besides Duke. We have a group from Elon Law School, and we also have a group from UNC, and I'm really, really glad to see that. And just to throw a monkey wrench into the conversation during the break, my students know I'm a big poll sort of guy, and there's an article that came out about 10 days ago from Pew Research Center referring to a December poll that found that 56% of Americans were more concerned that the government's anti-terror policies have not done enough to protect the country, compared with 28% who expressed concern that the policies have gone too far in restricting an average person's civil liberties. So I think that's an interesting, hope that generates some discussion during the break, which will last exactly 14 minutes. Thank you.